Good afternoon, everyone. Welcome to the public procurement episode of our Moncton Chambers series on the UK legal regime in procurement after Brexit, or legal regime after Brexit. And thank you very much to those of you who are attending today and for putting up with us having to postpone this event twice. I think that's just simply a reflection of the enormous volume of public procurement work that's been going on over the last few weeks and months. I'm sure those of us in this field will all have had this common experience. It's been rather a frenzied period. And as you will know, things have been going on other than Brexit, surprisingly, and they have had a dramatic effect on public procurement. Brexit is only part of the context for the ongoing revolution which we're living through in public procurement. And in some respects, Brexit leads to some rather less direct and immediate change on our law than in other areas. And I'll put on, once we've started, I'll put on in the chat references to a couple of blogs on the Chamber's website and on my blog, which set out some of the technical background, which I don't necessarily need to go into now, setting out sort of the legal parameters to how we're here. But in simple terms, you'll be aware that under the Trade and Cooperation Agreement entered into just before Christmas, very little was said about public procurement. Indeed, it's been said that the UK's position was that the TCA should say nothing at all until Dominic Cummings' departure from number 10. But what is in the Trade and Cooperation Agreement does raise a number of future questions, which are rather open-ended, as to how remedies are going to work under the agreement and how the Trade Specialised Committee on Public Procurement will operate. But again, we probably won't learn much about that until we get through the EU ratification process and see how that debate emerges. Perhaps the most important sort of replacement step, and the reason why Brexit itself is not such a revolutionary moment in public procurement, was that simultaneously with exit, we signed up to we acceded to the World Trade Organization Government Procurement Agreement. So we're still governed by international procurement obligations, which have at least the broad general structure matching that of the EU directives and public contracts regulations. So that, combined with the ongoing effect of EU retained law, means that we have a measure of continuity at the moment. The public contracts regulations, as you'll know, and the other regulations remain in place with a few relatively trivial, maybe trivial is the wrong word, relatively minor changes. The pandemic, of course, has shone a light on a number of aspects of procurement practice and regulation, which many of us who've been in procurement for years haven't looked at that much. And so it certainly caused quite a revolution in perspectives on public procurement. And Brexit has been the trigger for the publication of the Green Paper just before Christmas, proposing changes to public procurement law. And the consultation on that closed a few days ago. And I understand some 600 people responded, or 600, and there were some 600 responses. We're going to look at how some of these changes might develop going forward. But I think, well, maybe if I make a few general sort of starting observations. Firstly, many of the changes that are proposed are probably changes that could have been made within the context of EU law. And the only reason they haven't been made was because there was such a horror of public procurement law in particular, and gold plating an EU directive as a general sort of sin. So to some extent, we've had a sort of self-imposed limit on the ability to reform and improve public procurement law, and we're catching up with some of that. Some of the changes could not have been made until now, and some of those changes in parallel with the Green Paper do reflect increased ability to make change going forward. It'll be interesting to see what sort of structural changes happen. We understand that the changes are going to be made by primary legislation, which is an important change, but it does mean that we're going to end up not seeing any change for some time. There's not going to be space in the parliamentary calendar for timetable for some time, presumably until after the summer. Clearly, a great deal of reliance is going to be placed on guidance, and we'll hear more about that from the speakers today. And it'll be interesting to see what sort of legal obligations flow from that. There are already the powers to make regulations and binding guidance under the Small Business Enterprise and Employment Act 2015. but so far guidance hasn't been generally made under those powers, so they haven't had that sort of legal force. And there's obviously going to be considerable development in the area of remedies, which we'll come back. We're not going to cover today because I think it's probably a separate subject in itself. And to a considerable degree, the future shape of the remedies regime will depend on judicial developments, what happens in the TCC Users Committee, the Rules Committee, and perhaps most importantly, fundamental resource questions in the Courts and Tribunal Service. And finally, I make a sort of a UK constitutional point. We'll have to see what this all does to the breakup of the UK. But it seems to me, at least, that there are probably rather good reasons why neither Scotland nor Northern Ireland will be able to follow the same route as England in reform of its procurement law. And perhaps Wales may also take the opportunity to splinter away. So while at the moment we have a sort of fairly coherent central core of UK public procurement law with the Scottish variants in the regulations, we may end up with some quite different models going forward. So today, to explain some aspects of what we're going to be dealing with, we've got 4 stars of Monckton Chambers, going to cover 4 of the key subjects going forward. Ewan West is going to talk about procedures and criteria. The dream of slipping the bonds of procurement procedures is here at last. And we'll hear from Ewan whether that is going to be a dream fulfilled or we're just waiting for the lack of procedure to bite us back in the bottom. Azim Sutawala is going to talk to us about social procurement, the social model, which was put forward last year as a way to deal with procurement and how that's going to be developed and integrated into our new law. Khatija Hafezji is going to talk about the new policy note on reserved contracts and what that might mean and what changes might flow on from that. And Lydia Asepsiou is going to deal with perhaps I think probably the least well thought through part of the green paper, the area around frameworks and other purchasing systems. It's clearly very important, but it's not quite clear what is, at least in my mind, what is really being proposed. So I look forward to hear from Lydia as to what she thinks is going on and where we think we're going to go. So without more ado, I've already taken up more time than I said I would. I'm going to turn the floor over to Ewan to take us away on procedures. Ewan.
Thank you, Michael. Yes, as Michael says, I'm going to talk this morning about, or rather this afternoon, about the new proposals concerning procedures in the green paper, and in that, I will just get myself going. I called this procedures or the lack of them. What's the proposal here? Well, I just take you back. What's the problem? And one can see what the problem is from, as set out in the green paper. The assertion is too many procedures, some of which are rarely used, and the statistics there are actually quite compelling. Some of those opportunities that were brought in 2015 haven't been used. Too much complexity, a lack of flexibility, and a perception that the procedures are bureaucratic and process-driven. This was the phrase in the green paper that really struck me most of all. It's often the choice of procedure that drives the procurement, not the needs of the procurement that drives the procedure. So there's, in many respects, the general proposition that there may be a need for procedural streamlining seems to me to be fair made. I think many of us who work in this area would agree that ultimately we do rather come down to the same set of procedures being used, mostly open, restricted, and some sort of competitive dialogue, but that very often the procedure doesn't quite fit the situation. We've all had experience, usually through litigation, of seeing what happens when the procedure doesn't quite work. So what's the proposal? Well, there are 3 procedures there. This so-called new competitive flexible procedure, which I'll talk about in a moment, the open procedure, as now, and limited tendering procedure, which is effectively Regulation 32 territory, but with a new additional ground of crisis, clearly intended, one imagines, to deal with the sort of issues that have arisen in relation to COVID-19. And most importantly, no light touch regime. So we move forward, therefore, with three options. In fact, the limited tendering procedure, by definition, is not going to be able to arise, save in specific circumstances. So there will effectively be a choice between an open procedure and something which is this new competitive flexible procedure. So what does that mean? If one looks at what's set out in the Green Paper, there are many aspects that we will find familiar. Transparency of advertising, consistency of the process being followed with that which has been published. And this is my own attempt to summarize: compliance with published basis of selection and evaluation. This all sounds desperately familiar to those of us who've worked in this area. And I think it actually says in the Green Paper, say what you're going to do and then do it. It is very hard to see how any process could possibly be set up which didn't seek to achieve that aim. That would be a basic requirement of normal public law. The key difference, though, lies in the flexibility in the design of the procedure. And some examples are given. For example, the idea that you could negotiate with bidders to understand the requirements. So that's negotiation. It's to be assumed within the context of the procurement rather than pre-market engagement. Evaluating products before selecting tenderers. That seemed to be particularly important in the new technology field. And then a phased approach to develop solutions. All of these are issues which currently arise and which one has to sort out within the confines of most procedures. I think what it would appear to be, perhaps most obviously, is there's an attempt to have some of the issues that might be addressed in a competitive dialogue done in a more flexible way. In my view, there's no doubt there are some opportunities here. One of the problems of the current regime is it is not really immediately clear that what works for example, procuring a complex software solution is necessarily the same as procuring a realm of services, of social services. So more graduated approach, different types of procurement, different kinds of markets. How you run a procurement in a market which is by definition very limited, for example, where there are only one or two suppliers in the world, completely different to the sort of a market where there are hundreds of potential suppliers. The regime will explicitly permit for flexibilities where absence currently makes compliance with legislative requirements difficult. One of the problems one encounters time and time again in procurement litigation is that the procurement may start in a perfectly sensible way, but as the procurement develops, it becomes clear it can't continue on the track that it has done. Building in flexibility will help. And of course, the greater scope within the procurement itself to explore potential solutions, that seems to me to be obviously helpful. However, it's also the case that this regime may advantage, and again, the declared aim is to advantage startups, smaller businesses, something lighter, more flexible, less resource intensive. One can see that all of these are features that would be welcome, but they come with a number of problems, as it seems to me. There's no particular order about these, but they all seem to be problems that will have to be addressed, though undoubtedly will end up being addressed when new legislation is in place. Transparency may limit flexibility during the procedure. You cannot escape from the problem that you have to define at the outset that which is that you're trying to do and how you are going to assess. There is a danger of not ignoring the benefit and the tried and trusted. If you know how a process is meant to work, you know what you're letting yourself in for, both as an authority and as a tenderer. There's also the point that the benefit of having a choice carries with it the burden of a decision. At the moment, contracting authorities have a menu from which they can choose. There may be a decision point to be made about which procedure to use, but at least it's a fairly limited menu. It's rather like a set menu in a restaurant. We now have a full a la carte option, which does require thinking and determining the process. And one can easily see how contracting authorities just face another burden of deciding what the process is to be. But the effect of this new approach seems to me to be largely that of turning the light touch regime into the main procedure. What I would simply observe there, and it may just be a reflection of the sorts of cases that one finds that come to litigation. My experience is, in fact, in the light touch regime, most authorities have chosen to opt for one of the tried and tested procedures. In other words, they've used the restrictive procedure, maybe with a few bells and whistles on it. So one does question if the general approach is like the light touch regime, will there really be a great deal of difference? There are various other potential problems. Continued use of a process may actually end up giving rise to expectations, legitimate or otherwise. One can easily see how an authority, partly because of this issue of the benefit also giving rise to the burden of decision, in fact, developing that authority's own processes that will just become ossified. Infinitely varied processes can lead to confusion for the authority as well as bidders. This is an important point. In my experience, procurements that go wrong quite often go wrong because the process is too complicated. At the moment, that process is very likely to be, for example, having a number of requirements, each of which is evaluated according to a different matrix. And as sure as night follows day, at some point an evaluator gets the matrix wrong and applies the wrong scoring system. This new flexible procedure can simply give rise to that on a larger scale. And flexibility can also create uncertainty and import risk. And in this respect, I think it's particularly difficult when one looks at the thrust in the green paper towards proceeding by way of guidance rather than by way of something which is more black letter. There's a huge emphasis on guidance. And as Michael has suggested, there are already powers to issue guidance. The problem with guidance is it does not necessarily follow that it will be binding. That may be a matter that will need ultimately to come to judicial determination. And so, for example, having recently been in the case involving the challenge to publication of contract award notices, in that case, it was held that guidance that was expressed in advisory terms was in fact held to give rise to binding obligations. So proceeding by guidance looks like a wonderful way of increasing flexibility, but actually that flexibility may turn out to be illusory. And in fact, it may be even worse than that because it may create uncertainty. At least with a set of black letter requirements, you have certainty in the process. Because ultimately, there's still a need for ground rules. The difficulty one senses is that there's an attempt in the green paper to try to replicate a normal commercial contract making process. And that can never happen in a situation where one is bound by WTO, GPA obligations and where there's a need to be acting consistently with public law principles. So ultimately, this greater flexible procedure, greater use of guidance, it could in fact lead to more problems than those that it serves. Sometimes certainty and more black letter prescription can in fact be better. And there's no doubt at all, one can see in the early days, whatever the new regime is, there will be large amounts of litigation, I suspect, to establish just where the boundaries of this flexible process lie. That's all that I plan to say at the moment, but obviously if there are any questions, I'm happy to deal with them later.
Thank you, Ewan. That's terrific. Indeed, set out the problems very neatly. Just before I pass to Azim, just to point out, which I should have done before, we have the Q&A panel. So if you have any questions at all, do please pop them up there, and we'll try and make time to address them at the end. And on the chat bit, please don't use the chat. Please use the Q&A. But I have put up on the chat a couple of blog references, which I referred to in opening and when we started. And so there may be, if other things come along that need a sort of a footnote, an additional footnote, I'll put them up there for people. But without more ado, over to Azim Sutawala to tell us about the social model for procurement, the brave new world. Azim, take it away.
Thank you, Michael. Hello, everyone, and good afternoon. What I plan to do is to set out the law as it stands and where we are in respect of award criteria, and then to have a canter through how we've got to what is now termed the social value model. I'm going to try and get my slides up and hope that works. Yes, and we will go from there. So the law as it stands, Regulation 67 will be familiar to, I'm sure, all of you attending. That's obviously the regulation which makes good on the purpose behind public procurement law, essentially to foster fair and open competition. And it does that by obviously setting out the requirements of the award criteria that can be used by contracting authorities. And we have the terminology there of the most economically advantageous tender, referred to as MEET. That means you can award a contract on the basis of price or cost, or on the basis of price quality ratio. The key consideration has always been that qualitative criteria must be linked to the subject matter of the contract. And although there is clear case law from the Court of Justice that contracting authorities have a wide discretion when designing award criteria, the link to the subject matter of the contract has been always significant and been litigated as a consequence. And I refer to two early examples there, well-known cases: the Harrow case, which concerned a particular criterion being in the context of the management of housing stock, a bidder being able to indicate whether they would be able to take on that housing stock at a later stage. That was deemed by the court to be an award criterion which was not linked to the subject matter of the contract. And we see by contrast the well-known Concordia case, which concerned buses and nitrogen dioxide levels, where the court considered that it was clearly a permissible award criterion to have as a criterion environmental considerations to drive down emissions. So that's the background in terms of award criteria. Where have we gone since Regulation 67? Well, what we've had in the meantime, and obviously Regulation 67 is the process of a long line of authority on MEET, is the Public Services Social Value Act 2012. And this was announced with some fanfare back in 2012, and there was a great deal of discussion, and we ourselves, I remember, were undertaking seminars and talking to lots of people about, well, what does this mean, the Social Value Act, and what consequences will it have for contracting authorities? And you see their summary of what the Social Value Act was trying to achieve. Section 1, prior to undertaking a procurement for a public services contract, and it was limited to public services contracts, the authority must engage in certain considerations: how what is being procured might improve the economic, social, and environmental well-being of the relevant area, and how in conducting the procurement it might act with a view to securing that improvement. That was caveated with the requirement that an authority only consider matters that are relevant to what is being procured. So that's a subject matter link, and must consider whether it's proportionate to take these matters into account. Well, to my mind, that was a bit of a cop-out, frankly, in terms of the obligations on the body to take the matters into account. A lot of flexibility. Subsection 3, the authority must consider whether to undertake any consultation as to the matters that fall to be considered. Again, just a consideration as to whether to undertake a consultation, not a mandatory requirement that such a consultation must actually be undertaken. And then we see at the bottom of that slide, no need to fulfill these requirements when impractical to do so because of urgency. And of course, that's a hot topic and has been a hot topic in the past year or so. So the Public Service Social Value Act provided really a great deal of flexibility and was limited, frankly, to a requirement of considering relevant matters rather than actually doing anything, if I can put it that way. What happened to social value? Well, the original PPN set out that it did not, as we've seen, the Value Act prescribe the considerations, but those considerations should be recorded, and it would be good practice on contracting authorities to keep a formal record, no doubt to apply pressure, and this again through guidance, that the Social Value Act would have some sort of impact. There was a review carried out in 2015 of the Act. And interestingly, that review was to the effect that the Act was significant and had importance because it was non-prescriptive, and that the decision at the time in 2015 was that that should not be extended to impose mandatory burdens or obligations on contracting authorities, and that I think the terminology at the time in the review to do so would be akin to a box ticking exercise. That was a view taken in 2015. So where have we got to now? Well, we now have the social value model, and this has been announced and has come into force, in fact, as of January 2021. This was announced in the public procurement notice of September 2020, taking account of social value in the award of central government contracts, described as a new model to deliver social value through government's commercial activities. And the important point there, of course, is this is guidance that applies, has been issued and applies in respect of central government bodies, not other public authorities. What is the effect of the social value model? Social value to be explicitly evaluated rather than just considered. That is stated at the outset of the public policy note, and therefore you can see in effect this is a volte-face from the position taken in 2015, and in fact in respect of the Social Value Act 2012, which remains on the statute books and is meant to be followed as matters stand. Applies to all central government departments, executive agencies, and non-departmental public bodies. That's the scope of the new model. Very interesting, and I think this is very significant with the new model. There's never been a definition of social value within either the Social Value Act or guidance, and there isn't an express definition in the new social value model, but it's clear from the model itself that social value is now impliedly defined, and I'll come on to that in a moment. The model is mandatory, but flexible as to what outcomes apply, and we're going to look at those outcomes in a moment. And the key point is that there's a minimum weighting of 10% of the total score, which has to be applied to these outcomes. Now, what is social value in the model? Well, that's defined by the outcomes that are now set out in the model. And those outcomes are listed there, and you can see them for yourselves. But they're very interesting. I mean, obviously one is very specific to the time, COVID-19. But I mean, a range of factors, such as stewardship of the environment, reducing disability and the employment gap, and tackling workforce inequality. And one which I thought was very interesting, improving health and well-being and community integration. So quite a bold, on the face of it, a bold step in terms of defining what social value is and what the outcomes will be. And before I go on to the issues, I thought it'd be interesting just to set out how the model was meant to work in practice by reference to one of those outcomes. And the model is effectively a somewhat 32-page document that's been published, all guidance, by central government. And to give you an example, one of the outcomes, as we've touched on, is well-being, defined as theme 5 in the model. And the outcome is defined as award criteria where the subject matter of the contract involves the performance of the contract being labour intensive, the health and well-being of the contract workforce being important to the performance of the contract, and there being opportunities to improve the health and well-being of the contract workforce. And then there are 2 standardised criteria which are given, the idea being that these can simply be lifted and used by contracting authorities in running the procurements. And the 2 criteria: demonstrating action to support health and well-being, including physical and mental health in the contract workforce, and requiring bidders to show influence on staff, suppliers, customers and communities through the delivery of the contract to support health and well-being, including physical and mental health. And then the model sets out a standard model evaluation question that can be lifted by contracting authorities and then used in order to mark the award criteria, or as part of the process in looking at the award criteria. So quite a significant development. Finally, what does that mean in terms of issues going forward? Well, I suppose the first point is this is for central government bodies. What does it mean for local authorities or other public bodies? Well, we simply don't know at the moment, because of course this is guidance for central government, doesn't stretch beyond that. And of course, for other public bodies, they are required to follow the Social Value Act as it stands. They are required to follow guidance that's issued under relevant provisions to them. For example, the Local Government Act. They have other obligations such as best value duties under the Local Government Act 1999. So the immediate issue is how will this fit with the social value model? And to the extent that the social value model, the idea for government is to impose this in due course on other public bodies, it will probably have to do that by way of primary legislation, I think, going forward. Should there be a maximum cap of weighting? We've seen the minimum cap. Well, you can potentially have abuse, if I can term it that way, of the new model without having a maximum cap on weighting. And what is the relevance now of the Social Value Act? It all seems to be overtaken by the social value model. And in fact, the public procurement policy note seems to anticipate that. And then finally, will it achieve intended aims? Well, obviously, the model is intended to infuse social value in award criteria, and that much, I think, will be achieved because, of course, these are mandatory criteria, at least for central government departments. But another aspect that Ewan touched on of these changes is to level the playing field and give an opportunity to small, medium enterprises to win contracts. My concern is that by imposing, again, using terminology that Ewan's used, burdens, an additional burden on public bodies, is the reality that this favours those larger organisations that will have the resource and capability to be able to meet these criteria and produce polished submissions and tenders that deal with those. So that's food for thought. Those are my thoughts, and I hope you enjoyed the talk. Thank you.
Thank you very much indeed, Azim. That's great. And you point out the relevance of the fact that a lot of this is going to have to be sorted out in primary legislation. So it reflects the point you picked up already, that this whole reform is going to have to be tied together in some primary legislation. It's not entirely clear to me from the Green Paper how all of these threads fit together, but that'll be an interesting piece of work for the draftsman to be getting onto over the next few months, how this patchwork of existing legislation gets pulled together. So the next topic we're going to cover is reserved contracts, which is not strictly speaking dealt with in the Green Paper, but it's obviously part of the same post-Brexit programme of reform. And it's a great pleasure to have Khatija Hafezjuk to tell us about that. Khatija, take it away.
Thank you very much, Michael. Just going to get my screen set up. Can you see that, Michael? Great, okay. So I'm going to be talking about the PPN, which was published by the Cabinet Office in December last year, about reserving below threshold procurements. And it picks up on quite similar themes to those discussed by Ewan and Azim. And it does mark what I think is quite a significant departure from the pre-Brexit world. So most of you will be familiar with the concept of reserve contracts, but for those who aren't, essentially contracts are reserved where the contracting authority stipulates that only organisations which meet certain conditions can bid for the contract. There was a PPN published last December, which took effect on the 1st of January 2021. And the status of that PPN is to provide guidance on best practice for public sector procurement. And what it does is permit and encourages the reservation of below threshold contracts on the basis of location and or the type of organisation that can make a bid. And the PPN, as I say, applies to below threshold contracts. The thresholds for central government are set out in full in an earlier PPN 06/19, and that can be summarised as you see here, supplies and services around £123,000, and for works around 4.7 million. So who does it apply to? The guidance in the PPN is a pretty broad application, subject to the Northern Ireland caveat, which I'll come to. The PPN defines in-scope organisations as all central government departments, their executive agencies, and non-departmental public bodies. And as it was before, it's only relevant where Part 2 of the PCR would have applied, but for the estimated value being lower than the applicable threshold. But then it goes on to say that all other contracting authorities are encouraged to apply these principles. So as I say, it's of rather broad application, subject to quite an important exception, which is that it does not apply to supply services or works procurements where the goods are to be provided to Northern Ireland and where there is cross-border interest. So in that respect, the position has not changed much post-Brexit. Now, turning to what are the applicable bases for reservation, there are two bases upon which a contracting authority can reserve a below threshold contract. The first is on the basis of location, so i.e. only suppliers who are based in a particular area, for example, can bid for the contract. Now, that can be either UK-wide, where there is a need to support domestic supply chains and promote resilience and capacity. And again, you'll have seen similar language in the social value model. Or you can do that by county, including metropolitan and non-metropolitan counties, where that's needed to tackle economic inequality, support local recruitment, training, skills, and investment. And again, here you can see some echoes of the government's levelling up agenda. What you can't do is define location by reference to nation, so England, Scotland, Wales, and Northern Ireland, and you can't reserve more than one county if that's what you're going to do. The second basis for reservation is by type of organisation. So you can reserve a procurement for small and medium-sized enterprises and for voluntary community and social enterprises. Again, very similar to what we've heard from previous speakers. Now, these criteria can be applied alone or they can be applied together. So for example, you can say that only SMEs and VCSEs in Dorset County Council can apply for a particular contract. But the contracting authority must clearly set out in the procurement documentation that it's intending to reserve the contract and what criteria bidders must satisfy in order to be considered. What you can't do is make a direct award under this policy. So contracting authorities need to be really careful that they do not make the parameters so narrow that the procurement essentially amounts to a direct award to a single eligible supplier. In terms of sort of the important takeaways from this and things to note, it's quite important to look quite closely at the definition of location. So that definition is where the supplier is based or established and where the supplier has substantive business operations. It is not the location, and this is expressly said, the location of corporate ownership. So this means that a foreign supplier can participate provided that they have a UK base and substantive operations in the UK, or that they're based and operating in a particular county, which has been reserved under this policy. So it's not as straightforward as saying you can only favour UK companies or those who are, have corporate ownership in the UK. The legal requirements in Chapter 8 of the PCR 2015 continue to apply to below threshold procurements, and the PPN is very keen to stress that when reserving contracts in scope organisations should continue to adhere to basic principles like ensuring value for money, assessing the sector and the market, identifying and managing associated risks, including fraud and corruption, making sure that suitable model contracts are used, undertaking supplier due diligence checks, keeping suitable records of commercial decisions, and publishing timely transparency notices on Contracts Finder where that's appropriate. So they're quite keen to stress all of that. To sort of wrap this up and conclude, the idea of reserving contracts is clearly not a new one. We've always had Regulation 20, Regulation 77 that permitted the reservation of contracts in certain sectors and for certain organisations. And there was always the ability to reserve below threshold contracts pre-Brexit, but it was always subject to quite a stringent cross-border interest test. Now that test no longer applies post-Brexit, subject to the Northern Ireland caveat. This new approach, certainly on its face, constitutes quite a significant liberalisation, I think, for contracting authorities, but it also introduces quite a lot of scope to get things from, and we'll see how that operates in practice. I think that's over to Lij now.
Thank you, Khadija. That was fantastic. A lot of food for thought there. So, with the time marching steadily on, I'm going to turn over immediately. We've got a few questions building up. Do start any other questions, sort of put them on any of the topics we're covering, and we'll try and pick them up at the end. But our final topic is, I've used the shorthand frameworks, which covers this chapter, which I've already been critical of earlier on. It seems to cover all sorts of stuff. It certainly isn't confined. It certainly isn't confined to frameworks, although that obviously is the core of the chapter. And fortunately, I'm not going to try and make sense of it. Lydia Recepciu is. So, Lydia, over to you.
Thank you very much, Michael. But let's hope I can deliver somewhat on that promise, although I feel we may be getting to similar places. So as Michael says, I'm going to talk about the frameworks and DPS section of the Green Paper, focusing in fact on frameworks, but because that seems to be where there is the most perceived, there's the most impetus to make what the paper seems to be presenting as a really kind of radical change in this area, although there are sort of more fiddly changes being made to this notion of the DPS plus, to the current DPS regime with this notion of a DPS plus. So to recap on frameworks, what we're talking about and some of the current law on them, we're talking about agreements between one or more contracting authorities and one or more economic operators, the purpose of which is to establish the terms governing contracts to be awarded over a given period, in particular with regard to price. So we're more familiar with frameworks effectively when we set out the contracts that sort of set out the framework for an ongoing relationship, but don't at the outset provide for the quantities to be supplied or for any obligations, any guarantee that the contracting authority will necessarily take on those services or in exactly what quantities it is going to take them. Under the current law, there's a time limit on the length of the framework agreements under the PC, and this is all observed in the Green Paper. Under the public contracts regulations, they're time limited to 4 years. Under the defence and security regulations, they're limited to 7 years. And under the UCR, they're time limited to 8 years. So being the length of the framework, not any individual call-off contracts under the framework where those time limits don't apply. But obviously there are sensitivities about potential abuse of the framework process by awarding very, very long-term contracts pursuant to a framework agreement, and particularly when they're awarded right at the expiry at the end of the framework agreement itself. Currently, and still under the Green Paper, frameworks can be single or multi-supplier. So single supplier framework, the interest of that is, as I was saying, the authority doesn't have to commit to taking a particular volume of goods, services, or works up front, but can decide to down those requirements over time as they become necessary. Whereas a single supplier framework is put in place, there is those call-offs can be made up to a particular value cap that's specified in the framework agreement and has to be specified in according to the principles of transparency, to be specified in the tender documents as well. Where there's a multi-supplier framework, the interest is again no on the part of the contracting authority, no commitment as to volumes, but also a wider choice of suppliers. And there's a possibility under the current rules to either make a direct award without reopening the competition in the context of the framework, where there are sufficiently objective conditions set down for doing that, which is quite often not the case, or alternatively to hold a mini competition amongst the current suppliers, but that's without opening on the framework, but without opening it up to the broader market, and so therefore limiting the kind of work that needs to be done at that mini competition phase. Another quick couple of points on the current law as clarified a couple of years ago by the Court of Justice in the Autorità Garante del Concorrenza case, so this Italian antitrust authority case, which is C21617, where some of the rules about which contracting authorities can use frameworks were clarified. And the Court of Justice reaffirmed that a framework is open to authorities other than those who are initial signatories to the framework, provided that they're suitably identified as potential beneficiaries. And the suggestion there is that needs to be done relatively precisely, rather than in broad categories like the entirety of the public sector, or hospitals, or schools, things along those lines. The other, so that was the holding at paragraph 56 of the case, and the other key point to emerge from that case is that even where a contracting authority is not an initial signatory to a framework agreement, but is just identified as a potential beneficiary, that's no excuse for not providing an estimate of the value of the services that they will ultimately potentially be calling down under the framework agreement. And absent that sort of estimate, their entitlement to use the framework agreement is in doubt. So it was the Italian Competition Authority case really was a step in the European court crusade against what's been perceived as abuse of frameworks in a number of jurisdictions, taking advantage of the great flexibility afforded by them to have authorities pile in with requirements that they had never previously envisaged or advertised to the market that they would procure under this framework, rather than with a contract notice and through the usual processes. In taking pretty much the counterpoint approach to the European Court, who was trying to rein in these framework abuses in that case, the Green Paper's proposals really are about aimed at making frameworks more flexible, more useful, and more used. So it seems to be pushing in the opposite direction, adding greater flexibility to frameworks. But the key question is really, what does it achieve? Does it achieve very much, or do the current proposals as written achieve very much? So the proposal starts at paragraph 151 of the Green Paper, and there is a proposal to retain essentially the current type of framework agreement, which is called a closed framework, with a maximum duration of 4 years. And by closed framework, the distinction being made in the Green Paper is between closed frameworks and open frameworks. So closed frameworks are described as essentially the frameworks that we currently have in place. The framework is procured, whoever's on the framework is on the framework, and call-offs are made under that framework. Once it expires, unless there is some mechanism for extension under the regulations, it's expired and it needs to be reprocured. The open and so the proposal for closed frameworks is that they stay very much as they currently are under the Public Contracts Regulations 2015, maximum 4 years duration. They can be with single or multiple suppliers, and it's a one-off competition process. And there's a proposal for open frameworks, which would effectively be similar to the closed framework agreements, save that they would be longer in duration, so for a period of up to 8 years. They would be closed for the first 3 years, so no one can, once the initial procurement is conducted, the suppliers then selected have got a 3-year period of exclusivity. But after that 3-year period, open frameworks can be reopened at designated points at the discretion of the authority. Not entirely clear in the from the green paper whether these have to be specifically defined designated points in the future. These designated points for reopening have to be defined from the outset, or whether this is something that's at the border of discretion of the authority later in the period. When when the authority who's running the framework reopens, it's envisaged that they will be entitled to assess any new applicants to the framework, but applying the same requirements and evaluation criteria as applied when the framework was originally awarded. There should be an opportunity, it is proposed, that suppliers already on the framework are entitled to update their bid or submit a fresh bid at the time of reopening. However, if they decide to do so, they might find themselves unsuccessful on their second bid. It is envisaged that commercial teams can limit the number of suppliers on even an open framework. However, if you have rather than an open-ended multi-supplier framework, a limited multi-supplier open framework, everyone's bids, including the bids of those already on the framework, have to be reassessed with each reopening. And obviously, those on the framework, as previously said, would need to be given the opportunity to rebid. Contracting authorities will also be required to include terms in framework agreements, allowing them to remove suppliers on exclusion grounds, on mandatory or discretionary exclusion grounds, subject to self-cleaning. That seems more of a tidy up. It's not one of these reform proposals. So what to make really of these proposals? In respect of closed frameworks, I said there's not really much change that one can glean from the face of the paper relative to what currently happens under PCR 15. And obviously, it's actually a reduction in the length of these closed frameworks relative for the defence procurement regs and for the utilities contracts regs. And the open framework proposals are clearly intended to open up the market, in particular to open up public markets even further, in particular to small and medium-sized enterprises, which are expressly mentioned in this section of the Green Paper, and to generally give more opportunities for competition. However, from the perspective of the authority actually administering a framework, it is very difficult, certainly for me, to see how opening up the framework after the initial 3-year period is going to be materially different from a reprocurement of the framework generally. At least where there is a limited number of suppliers, it's clear that there's going to be an obligation to reevaluate all the tenders, even those already received, and even if those on the framework are not interested in updating or submitting new ones. And I think, as we all know, the real the meat of the work and the really difficult work in conducting any procurement competition is that evaluation exercise, and it seems like that's not something that's going to be the burden of that is not going to be something that can be avoided with a multi-supplier, with a limited multi-supplier framework. You might cut down some of the other procedural steps, but that in terms of the saving for the commercial teams, that's fairly, those savings are potentially doubtful. You might also have difficult questions raised around the equal treatment of bidders across bidding rounds, particularly where someone hasn't, where those on the framework have not already submitted bids, or where there was more scope for discussion with bidders in the first round of procurement that's not, and it's difficult to accommodate that in later reprocurements. So for my part, little time saving for the authority administering the framework. There is some time saving and process saving potentially where you have an open framework and you simply open it up, a multi-supplier open framework with an unlimited number of suppliers, and you're looking to add more economic operators. Because at that point, you're not reassessing you're just reassessing fresh bids. You're not reassessing necessarily all the bids that have already been submitted. That starts to look much more like a dynamic purchasing system in many ways, although there is more scope for considering and evaluating quality. But having very large open frameworks from the perspective of a framework user means that you're probably more likely to require a mini competition rather than being able to place the contract directly. So it's shifting then these potentially very large open frameworks that you might end up with, where you do get saving on the administering authority side, seem to be shifting some, may just shift some of the burden or more of the burden of the evaluation and triage process to the contracting authorities actually using the framework. From the perspective of economic operators, again, for my part, it's hard to say what additional opportunities they're being given beyond those that they have currently to compete to be on one or more government frameworks every 4 years. I mean, under an open framework, it's true that the initial period of exclusivity, the initial close period is 3 years, so that's slightly shorter, in practice, if the rest periods of between reopening the frameworks are quite short, then maybe so frameworks after the initial 5-year period of reopen, say every 1 year, there can be a really a very material opening up of the market there, but that will be very much at the discretion of the governing authority. It's also interesting that to see how that could interact with the Italian Competition Authority case, where you're envisaging these very long framework periods, and yet you have a requirement on contracting authorities to specify in advance their potential quantities, and how those two things work together is the deeply puzzling thing. My conclusion overall is that it's my views overall on the proposals are that they're framed in relatively high level terms at this particular level of detail. It's difficult to see exactly what problem they're trying to solve and whether they're going to solve it. Michael.
Thank you, Lydia. Yeah, I think it's been a common, looking at some of the responses to the consultation I've seen so far, there's been a bit of a lot of people have been scratching their head thinking you haven't really given enough concrete detail to consult yet. I think perhaps it's the weakest part of the whole package to know what's going to go forward. There are a couple of questions on frameworks in the Q&A, Lydia, which I might, if I give you a chance to catch up with, have a look at and see whether you have a want to come back on, but I won't put them to you quite yet. Maybe you draw breath. We're running up to time, but maybe if I just take a liberty of stretching over 4 or 5 minutes just to pick up a couple of the questions which have been thrown in. Khadija's had to drop off, but she's already answered in the Q&A a very pertinent question about the application of Section 17 of the Local Government Act, which I think probably just highlights why it's going to be so important. One of the recurring issues in some of these questions is the interaction of a lot of this between the proposals and existing primary legislation, and why it is going to be important that the primary legislation is properly considered, so it cleans up what amounts to an awful lot of loose ends in the legislation now. But maybe I can throw an unfair question to Azim, which arises out of one of the questions in the Q&A, which is, all of this social stuff is really interesting, but who's going to enforce it? Who's going to have standing to bring a challenge? And what really counts as too much or too little, or not the right sort of, or the wrong sort of social content?
Some easy questions.
In 60 seconds.
They're both very interesting points. I mean, on standing, obviously we've got the recent decision of Mr. Justice Chamberlain in the Good Law Project case, which revisits the Chandler case and the line of authority at first instance. So that's the latest word, and I don't know whether that's going to go any further. Well, I don't think it's going to go any further, but I don't know whether the standing issue will be reconsidered by the Court of Appeal at some point. I mean, to my mind, on standing, you could have a situation, of course, where you have an economic operator who has lost out as a consequence of the application of the social value, the incorrect application of the social value model. And they would clearly have standing to bring a judicial review challenging the failure of a central government body to correctly follow its own guidance. And of course, the principles as to public law principles as to a public body being required to follow its own guidance are well established. And I think you probably, in the light of the Good Law Project decision, could have a body come along saying that it has sufficient public interest to bring a challenge against the failure of a central government body to properly follow the social value model. So I think standing is probably covered. In respect of your second point, which is, well, what about too much and too little? That really is difficult. And I mean, that's a hypothetical without the facts, and is hard. I mean, could it be done? Possibly, I think, on the basis that you could try and tie it back to the regs and say that the effect of following ultimately, regardless of the guidance, the way that the guidance has been implemented in a particular case means that Regulation 67 hasn't been complied with, or the principles of transparency and proportionality or equal treatment have not been complied with. So there's probably a way to construct an argument, I think, and I suppose we'll have to wait and see. Watch this space.
Thank you, Azim. In the old days, I'd say I'm keeping you all away from drinks and refreshments, and I'm very sorry that we can't offer you that. I look forward to the point in the future when we can offer you drinks and refreshments at this point in proceedings. But we still probably all want to go away and get our own lunches or whatever it is that we're doing. In the short time available, some really important questions have been thrown up on your talk, Elijah. I think you've covered some of them as they were going along, but if I give you, in 60 seconds, is there something you want to sort of pick up from the questions of the Q&A, or is it not a 60-second answer?
Well, I shall attempt a 60-second answer. It shall no doubt be unsatisfactory. I've seen on the first comment that yes, it's a very good summary of where I got to rather laboriously. Professor Arrowsmith has been rather pithier than I mean. What's the point of an open framework? Just procure a new framework. That's really the answer to that's really the question to be answered in the drafting out of the detail of this. On the question about concessions and whether there's sufficient flexibility in the green paper to procure a framework for concessions, it's interesting. I've just looked back at it. The green paper expressly frames this as a regime for all contracts going forwards. Doesn't seem to make a concession distinction, and doesn't really appear to have thought about it very much. So yes, a good question, I think, on the current reading. It appears to be potentially envisaged, but it's that seems to have been possibly more out of negligence than by intent.
Yeah, fair point. I mean, we'll have to see how. Yeah, it'll be a new concept if that's what it is. It does end up covering. there's clearly a great deal more to be done in this area. I think that although this was a green paper, I think there's actually quite a lot more work to be done before this area is ready to be put forward into a draft bill. I mean, there's been a lot of chat as if somehow you can go straight from this green paper to a draft bill, and I think there's a much wider gap here between where we are now and a draft bill than there often is. And I think the opportunity to comment and consider where we're getting will come up again and again as the year develops. There no doubt will be much to discuss about procurement law. There's certainly a lot more case law and a lot more to talk about going ahead. It's been great to have so many people here. We've had well over 100 throughout, and it's been a great pleasure to have you. I'm hoping that we'll have many more procurement events and probably Brexit events, and maybe both going forward as the year develops. I hope that at least some of them will be in person and that we can enjoy at some point, inviting you to a drink, whether in the Gray's Inn walks or whatever. When I was there this week and going to a real live court, the daffodils were blooming, and those of you who are used to being in chambers, it was rather lovely to see the daffodils bursting out of the banks in Gray's Inn walks, and sad to see that the clients and members of the chambers aren't there to watch springing in WC1. But I look forward to seeing you all again soon. Thank you very much for joining us. À bientôt. Cheers, everyone. Thank you very much indeed for your participation.